Already we have discussed regarding the first four questions which deals with natural law school, and the question number 5, that is distinguished between law and morals, discuss the view of jurist of natural law school and positive school about the relation between law and morals. And the question number 6 is, law is the command of a sovereign containing a common rule of life for his subjects and obliging them to obedience. Discuss. And question number 7 is, evaluate the contribution of HLA hot to analytical jurisprudence. And now we'll go to question number 8, that deals with state the shortcomings in the definition of law given by Austin. How far HLA has been able to remove them in his own definition of law. Discuss. Question number 9, the concept of positivism has been changes with John Austin and HLA are elaborate. And question number 10, international law is vanishing point of jurisprudence. So up to question number 5 to 10, which deals with the very difference between natural law school and the positive law school, to differentiate between what is law and what are the morals. As already we studied natural law school, where the morals are being given far more importance than the very positive concept of law. And behind every moral principles, there are moral sanctions or social sanctions, as while regarding law as a positive concept, always behind it legal sanctions are there. And secondly, how the command of the sovereign is law, and if anyone disobeys the very command of the sovereign, then behind every command there is sanction, as it was decided by Austin in his analytical jurisprudence, and how the very shortcomings of Austin's definition of law was fulfilled by HLA Hart by providing his basic theory regarding law on supplementing the very rules, and those rules according to HLA Hart are primary rules and secondary rules, and those primary rules are always supplemented by the secondary rules and commanding both, that is law as per HLA had. And regarding the very concept of positivism, what changes were brought by Austin from the very concept of positivism as it was contributed by the French philosopher Auguste Comte, and how it was utilized by Jeremy Bentham, and the very disciple of Bentham was John Austin, and how John Austin made it an analytical, positive view of law, and in spite of that, he left certain points which were supplemented by HLA had by contributing his theories of rules, which consists the primary rules and secondary rules. And besides that, how international law is a vanishing point of jurisprudence, as it was expressed by Holland. So according to Holland, international law is the vanishing point of jurisprudence exactly means that he do not consider international law as a positive law, as already we have discussed regarding the very contention of positive law, that it is a command of the sovereign, and behind every command there is a sanction. And the question number 11, that is the movement of progressive societies, has headed to win a movement from status to contract. In light of the observation, discuss the contribution of Henry Ben. Then question number 12, critically examine the theory of Vogt as propounded by Savigny. And question number 13, explain Kelson's theory of pure law. And question number 14, which deals with discuss the characteristic features of the sociological school of jurisprudence. And question number 15, explain Pound's theory of social engineering with the help of illustration. Question number 16, that is write an essay on the authority of precedent as a source of law. So, when the very question movement of progressive societies has it to win a movement from status to contract, it was the contribution of Sir Henry Mann, and it refers to historical school of jurisprudence and how the static societies were based on status, and all the Eastern societies are status based, and when the Western societies they moved from the very static to progressive societies, then there was a change from status to contract. So that was the contribution of Sir Henry Mann, and the very concept of Vogt as propounded by Carl von Savigny, the German historical school jurist, and according to him, Vogt is the popular consciousness or the popular spirit of the people, and that is law. And according to him, law is found, it is not made by man. And regarding Kelson's theory of pure law, Kelson separated all faculties of humanities such as psychology, philosophy, history, economics, political science, sociology, etc. from law. And according to him, law is pure and it is an independent entity. And regarding that, he made the very pure study of law, and that theory is considered as pure theory of law. And besides that, the sociological school of jurisprudence, which as a movement started in United States of America, and the very theory gave much importance on social individual interest, and the main importance on social facts, social needs, and the individual's needs, and which actually frame the very manifestation of law. And in light of that, Roscoe Pound, the American sociological jurist, announced the theory of social engineering, and according to him, in that theory of social engineering, there would be an attempt to synthesize the individual or private interest with public interest and vis-a-vis social interest, and in this way law will be framed. And regarding precedent as a source of law, and as precedent, it exactly refers to all the decisions delivered previously by the highest court of law or the higher courts of law, and which should be subsequently followed by the inferior authorities or inferior courts in the same case regarding the same facts. And now we'll go to question number 17, which deals with make a comparison of precedent and legislation as source of law, and which according to you is the effective source and why. And question number 18, examine the adequacy and validity of custom as a source of law. And question number 19, explain what do you mean by right duty relationship. What is peculiar in right duty relationship in human rights? And question number 20, examine the very concept of rights in its wider sense of the term as propounded by Hofield. So, if we discuss the very different sources of law, almost we found three important sources of law, as one is custom, the second one is legislation, and the third one is precedent. And as we know, custom is the traditional and the oldest source of law. So it is an evolutionary process or method by which law emerges according to those who were the enunciator and exponents of as custom is the source of law, and regarding legislation, that is the modern source of law, and as all laws made by the legislature and legislator are the representatives of the people, so they have the sovereign authority to make law. So, in the modern sense, legislation is the real source of law, and those jurists and experts in law, they consider all the previous judicial decisions of higher courts are to be followed by the inferior courts, and those precedents are having substantial importance in lawmaking. So all laws that emerges only from precedent, and when we look at the very question regarding right duty relationship, and we have already discussed regarding that what are the rights and what particular relationship have been there in between right and duty. So also we have discussed regarding all the above concepts, and those questions up to question number 20 that already we have discussed in all our previous videos, those we had already uploaded in our channel. So, I would like to request all the viewers to go through all those videos already we have uploaded in our channel to find out the correct answer regarding the all 20 questions just now we have finished